how did you change it, or what was your intent, or what did you do, and was it a proper change or whatever, you still can challenge that. But at that point, excuse me, strike that. But at this point, it's not a factual argument. A factual argument would be, why did he do what he did, and whether or not then the legal part would come, whether or not it was legal what he did. Okay? All right, go ahead.
So he can actually go in and amend the ticket even though he's swearing under perjury, under one accident, saying that one incident happened, and then go in and do it. Because I was under the impression that that would make it, he's not a very good witness, and since he's the support for this whole claim.
Okay, let me see if I can answer your question. Mr. State Attorney?
Yes, sir.
Your question was, can he actually amend it?
Yeah, because he testified under oath when he put his signature on it.
Absolutely he did. And he also testified that same oath applies to any amendments. For whatever reason, again, I don't know why he changed it, okay? Yes. Maybe the facts and circumstances of what was going on at that particular time, he felt that, hey, this is a more applicable charge. Even though I initially charged, let's do this. Even though I initially charged A, based upon any other conversations or whatever he had or saw, he decided, you know what, B is a better charge that fits this situation. So even though I already wrote out A on my ticket, I'm going to use my authority as an officer and my discretion to change it to B. But I'm still going to use the same document. I'm still swearing that I'm a proper officer. I did the right thing. I'm gonna strike out what I did under A, change it to B, and initial it that, hey, yes, I made this change on this date. He still would be called to answer why he made the change. So it's perfectly legitimate that he can make that change. Still doesn't mean that he can't be challenged on it. Okay, but the question now that I have to deal with your motion is a legal basis to dismiss. Okay, why do you want me to dismiss that?
Well,
yes, sir?
The first grounds, I'd like to see if it can be dismissed on the speedy trial rule.
Okay.
That's one, because the ticket was 2 years old.
Not a problem. Hang on a second.
I'm sorry.
All right. In your motion.
No, that's
in your notice to dismiss, motion to dismiss, do you raise the issue of speedy trial in the motion anywhere?
No, I did not.
You did not. Okay. So now I guess I would take that as an oral motion.
Yes.
Or what's known as an oral tennis motion to dismiss based upon speedy trial. Okay. Citation was issued on June 4, 2010. Mr. State Attorney?
Yes, sir. I have that on July 14th, 2010, which would have been the following month. There was a capias issued, and that capias remained outstanding through, what I can tell, till at least October 31st, 2011. And the defendant was not actually then again present for arraignment until August 14th, I believe, of this year, 2012. So
what's the date capias issued?
My notes indicate July 14th, 2010.
7/14/10.
Yes, Judge.
Okay.
They would argue that constitutes a waiver of a right to speedy trial.
Okay, and then when's the next court date that the gentleman had, if you are aware?
The only next court date that I have in my notes, which are admittedly a little unclear, is August 14th for arraignment. And I don't have a year.
Excuse me.
I'd be assuming that's 2012, because I have a note that in October 2011, the capias was still outstanding. And
when now?
I'm sorry, I have that in October 2011, the capias was still outstanding, and then the only other court date I have written down is August 14th. So
August 14th of this year?
I don't have a year, but I would assume that if in October 2011 the capias was outstanding, it must be for August this year. That's the only next August chronologically.
Okay.
So. And then I have that on August 14th, that arraignment, the defendant pled not guilty. It was set for 9/19/2012. I suppose for dispo, which I think was last week, and And then that brings us to today. I think last week you must have continued it to today.
I did,
Okay.
because the gentleman just filed this paperwork. Mr. Clerk, does our system show that, a previous KPS was issued,
Yes, sir.
and when?
The original one was, July 15th.
Okay,
So I'm off by a day.
2010?
Yes, sir.
And you said original, were there subsequent KPS
Well,
issued?
let's see. That was served in July. No, it was a series of, no, sir.
So no subsequent
No
KPS?
subsequent.
But, okay, so we did have one issued on or about July 15, 2010,
Served
and,
on July 30th, 2012.
okay, KPS was actually served,
Yes, sir.
okay? 7/30, 12,
Yes, sir.
so it remained outstanding until that time,
Yes, sir.
okay? And do we know whether or not the gentleman was taken into custody? He subsequently was released on his own recognizance, or he bonded out, or? Okay, while he's looking, sir, I'll address you. Did you get arrested on this charge at some later time? No?
Sir.
Okay, not a problem. Yes or no? Yes, sir?
I also did appear at that actual hearing,
Which hearing, sir?
the hearing in front of Margaret T. Courtney, I believe that's who it was.
When did you appear for Judge Courtney?
At whatever the scheduled date was. They were actually outside of the courtroom with me, my family.
Okay,
And the woman, basically the same issue I had here was that she, when I stated that I was changing my name, she said, I don't have time for this, and she issued a case and told me to tell Mr. Beckworth that there was a warrant for his arrest. And I'm standing there, and she calls the next case.
okay.
And so that was how that went down, but I did file paperwork affirming an actual appearance as well. So I was assuming that should...
Affirming an appearance for that date, sir?
Yes. And because I filed numerous requests to dismiss this case and other things.
Okay, well, let's stay on track here.
Okay.
Because what I'm trying to find out is if you filed some documents indicating that you were in court on that date being on about July 15, 2010. That's what I'm looking for. Okay. Here's the capias.
Case was set for arraignment
Okay.
on July 14th, 2010.
Okay. And then we have,
On that same day, a certificate was issued for failure to appear.
okay.
From that point on, it's a series of pro se documents going back and forth between the judge's office and the clerk's office.
I see a copy of the capias that was issued here, sir, back in July 16, 2010. But what I'm looking for is something that was filed by you asking the court to recall the capias or set it aside, because in effect you are saying that, hey, I was there, even though, you know, you're saying that the court did not want to recognize my name.
I mean, I have a mandamus. I had a mandamus in the circuit court against Miss Courtney, alleging certain events to that effect, but I actually didn't bring it.
Ooh, you just put a whole nother wrinkle on this situation there.
Because, well, she actually moved from transfer after I had filed it.
I understand that. But what happens is, if you file a motion for writ of mandamus against the judge predicated upon what the judge did or did not do in reference to your case, okay, that action effectively stays with the case, okay, even though she's not here anymore, all right. Then if there is a writ of let me finish, sir. If there's a writ of mandamus, then the question now becomes whether or not I even can hear this case, because you have taken some action to take it to a higher court, to say to that higher court, you disagree with some actions that were taken by the judge at that time. You follow me? And if the court agrees with you and says, yes, you know, she was wrong or she did something that she shouldn't have done and so forth and so on, and then directs certain action to be taken based upon your file, not based upon her personally, but of the file, then I would have to take my direction from that court, because the court is still considering your action.
Well, under that case, the court actually, it's styled under Brother Brian Edward off of the Bay.
Okay.
So that's, well, no, I'm just, you know, bringing clarification to it. But okay, so my filing of the mandamus against her because she denied a dismissal, I filed a mandamus in a higher court. The mandamus, he denied the dismissal, but the case is still open.
Who denied the dismissal? The higher court?
Yes, the higher court.
Okay, well, that's good.
Okay, so
well, good in terms of it clarifies.
Well, it clarifies that
that particular point. So the case is now properly back here. Okay, great. Hang on one second. Yes, sir.
There was a pro se motion to recall the case was filed in August 2011.
Okay.
Sent to the judge, and it was denied.
Okay.
That was in 2011.
Okay.
I do have a copy of a motion to recall capias, Judge. Mine doesn't have a date on it.
Okay.
That sounds like it could be.
August 2011. Those are words that I just pulled up.
So 8/2011, pro se motion to recall, which was denied. Is that right?
Yes, sir.
Okay. All right. Based upon the information that I've gotten, that the fact that there was a capias, the offense date June 4, 2010. There was a capias issued on or about July 15, 16, 2010 for a non-appearance by the defendant, Mr. Beckworth, also known as Mr. Bay. Okay. And I'm making this statement, sir, for my court record.
Nah.
Okay? I recognize the fact that you want to be referred to as Mr. Bay. I have no problem with that. All right. There's nothing in the court file in the record that indicates that any motion to recall and or set aside was filed until on or about August of 2011, when there was a pro se motion to recall the capias, and that motion was denied, which means that the capias remains outstanding. Then I have a copy of the Hillsborough County Sheriff's Office jail screens indicating that the warrant capias was actually executed on July the 26th, 2012. So because of the fact that there was an outstanding capias, then that outstanding capias indicates to the court that you were unavailable for trial, which then would otherwise waive the speedy trial. So I'll deny your motion to dismiss predicated upon a speedy trial issue. And that's my ruling on that point. Now, let's deal with anything else that's in your motion, sir.
Okay, well, my main thing is, again, the state of Florida is foreign to the land. Of this land. Yeah, it's a limited liability company, and then I don't have any contract that actually states that I can actually be liable for a no valid driver's license. And that's again based on the fact that I didn't sign up. I didn't sign anything with that officer agreeing to that.
Agreeing to what, sir?
To the actual charge of no valid driver's license.
Okay. All right. In your paragraph 2 of your facts, you said the plaintiff, state of Florida, is foreign to the land. Which land are we talking about?
The land upon which the ticket was issued, this land. I'm sorry, the United States of America.
So how, in fact, is the state of Florida foreign to the United States of America?
Under the rules, because it's actually a limited liability company.
It is?
Yes.
State of Florida is a limited liability corporation?
Yes, I'm sorry, yes, corporation.
How? How so?
Based on its connection under the 14th Amendment and the actual the 1860s union between the states and the actual the United States of America, they all became federal enclaves.
Okay.
So since
So if it's a federal enclave, how is it then a limited liability corporation?
because a limited a corporation, a person, a state, or anything. I'm sorry.
Take your time.
Yes. A person can qualify as a corporation or an actual company or a limited liability corporation or anybody or an individual, because an individual is anyone with a social security number according to the code rules. So
According to what now?
I'm sorry, according to the actual code rule, what is it, the IRS code, an individual is anybody with a social security number. The state,
Okay, go ahead.
the state actually does have its own social security number and its own number that actually traces back to the United States.
And that social security number is what?
I am not apprised of it, so I have no idea what that is.
Well, there lies part of the problem. If in fact your argument is that because the state of Florida is an entity with a social security number or any other identifying number which connects itself back to an earlier agreement, part and parcel of making it a limited liability corporation, then you have to be able to prove to me that that is in fact the case by giving me, hey judge, here is the facts, here's a copy of the social security number, here's a copy of the identifying number, which makes it and establishes that the state of Florida in itself as an entity, because the state's not a person, it's an entity.
Okay, but even the state itself hasn't denied it.
The state hasn't said anything yet, because it's your burden.
Well, I understand that, but I also know, according to the rules of C4 dismissal, it's up to him to actually refute the facts I've thought out.
You didn't file a C4 dismissal.
So if I style it as a C4 dismissal and amend it as a C4 dismissal and file it, will that officially hold them to that burden or no?
I can't answer that.
But you just answered.
No, I didn't.
No.
Because you just changed the question.
Okay, all right.
In order for me to answer that question is I can't answer that. And the reason that I can't answer that is because I would be giving you legal advice as to what to do, how to do it, and when to do it. I can't do that. I can't be the judge and your lawyer too. I can only hold you to what you actually did file.
Okay.
Okay. That's why I took it one thing at a time. Even though you didn't raise the issue of speedy trial in your motion, I gave you some latitude, let you make an oral motion, okay? And we discussed that and then moved on to the actual motion itself. I just was curious when I was reading when you say that the plain state of Florida is foreign to the land, and you clarified and you said that to the United States of America. I mean, okay.
Oh, and also the actual representatives for the state are also foreign officers as well, because
Who's foreign officer?
Well, he's actually sworn to the bar. The
Okay.
officer himself is actually sworn to a private security agency.
What private security agency?
I believe the Tampa Police Department.
The Tampa Police Department is a private security agency?
I'm sorry. A private company that polices the land here.
Private company.
Yes, they are a private company. They are not a public. It's not a public company.
Tampa Police, okay, hang on, let me make sure I understand your argument. Tampa Police Department is a private company, not a public governmental agency. Is that fair?
I do not believe it is a.
That's different. I'm just questioning what you believe.
Oh, okay.
Okay, I'm gonna try to understand your argument, sir.
According to my understanding and in my argument, yes,
Okay.
Tampa Police Department
It's a private company.
is a private company.
Not a problem. Show me your proof.
I didn't bring any proof. No.
Mr. Bay,
Yes, sir.
you got me at odds,
Well,
okay?
no,
Listen to me.
okay.
Here's what my point is. I'm trying to take your argument.
Mhm.
First of all, understand what your argument is. And that's what I'm taking this. I'm not trying to nitpick or I'm not trying to be disrespectful or anything like that. I just want to understand your argument. And that's why I want to take it one step at a time. So when you make a statement that as part of making your argument that, hey, I believe that Tampa Police Department is a private organization. Okay? Okay, fine. Then you have to have some evidence to the fact that, hey, it's a private organization and here's why. You follow me? Here's the documents, here's the information that establishes the Tampa Police Department was established on such a day, such a time as a private, either for-profit or not-profit entity or whatever it is, okay? Therefore, they don't have the requisite governmental authority, if that's where you're going with this. Okay, but you just to tell me, well, I believe it is, that's not legally sufficient.
Okay.
That's the problem.
Okay.
And I'm not saying at this point, I'm not saying it is or it isn't. Okay? Next.
Okay. Oh well. And then the other one is the fact that
Excuse me.
I can't even say according to the law. It is my understanding that
Okay.
a corporation cannot interface with a human unless the human agrees. So I do not wish to do business with this agent for the state. I do not wish to be in any business with this agent for the state, especially in this matter.
Okay.
And I mean, I think that deals with the whole self-provision and the right to happiness. And if I'm not happy in dealing with the state, then shouldn't it be a little bit abusive of the state's office and its duty to protect and support the rights of the people if a part and parcel of the people aren't happy with what business they're offering?
Okay. I can't answer that question the way you frame it, as to whether or not you had a right to be happy or whether or not what the state as an entity is doing to make you happy. The converse argument would be that the state could not be happy with you for driving with not a valid driver's license. The requirement that you, in operating a motor vehicle on the highways and byways of the state, that you otherwise be sufficiently licensed. Okay? So, I mean, I'm not making that argument for them. I just want you to look at the reverse
But
of the situation. Okay, hang on. And my point is this. The basis of your motion today is a legal argument. Okay? Whether or not this case should be dismissed because it is legally deficient in terms of the state presenting a charge. Just because they charge you does not necessarily mean that you are guilty of anything. The charging document does a couple of things. One, it puts you on notice as to what the state claims, what law or laws that the state claims that you are in violation of. Okay, it gives you, excuse me, date, time, place, and some general information. Okay, put you on notice. And it also gives you the opportunity to defend yourself and basically say, hey, I am not guilty of this charge. I did not commit this offense. When you do that, you engage the due processes for you and the state. The state in regard to the legal process by which they bring the charge, because the state has the burden to prove that you are the person that committed this offense and that you are guilty of committing the offense, okay? You, on the other hand, do not have to prove anything. All you have to say is, not guilty, didn't do it, okay? Which invokes your due process rights. If you choose, and no one can force you to testify, but if you choose to testify, which is your right under the Florida Constitution and the United States Constitution, then you can speak up on your behalf and say, hey, didn't happen what they say, I wasn't there, this is wrong, so forth, so on, state didn't prove my case, therefore I am not guilty. But at this juncture, because we're at the front end, as opposed to the middle or the back end, okay, the question that I have to determine from a legal standpoint is whether or not the charge is legally sufficient in terms of informing you of what the charge is, giving you an opportunity to respond. That's why when you brought to my attention about the change, how they initially charged you and then it was changed, and once I realized and saw the charging document, and I believe I answered that question, is yes, the officer can legally do what he did in terms of changing it, initialing the change and dating the change, and still he can be still questioned as to why he did what he did. Now, if he did something improper, it comes out, then that's a horse of a different color. But at this juncture, can he do rather what he legally did? And for the case to proceed, the answer is yes. Okay? Now, if there's some other legal ground for you want me to dismiss the case, and that's why when you raise these points, you have to have some evidence to show me, hey, the town police department is a private entity, or the state of Florida is a limited liability corporation and has a social security number, some other identifying numbers, which does not make it such that it can go forward against me. The fact that you believe that to be true without showing me some written documentation, evidence, some law to that effect, didn't give me anything to go on.
Okay. So, all right. The state officials, public officers, they're being duty bound to uphold and support the Constitution. And
Absolutely.
The Constitution being the supreme law of the land. I haven't violated any provision of the Constitution, and the state is not attempting to exercise any self-executing provision of the Constitution. So how is this claim actually valid, and how is he not, whoever's sitting in his office at whatever
The
time?
assistant state attorney.
Okay, well,
Right.
yes, how is he not actually in violation of his duty oath if the claims that he's alleging aren't anything to do with the enforcement of the supreme law of the land?
Okay. You want to opine on that, or shall I?
Just briefly state that federal government grant police powers to the states, and that's what we're operating under.
And this is not a constitutional issue. Okay.
But it is for me, though, because I feel like my constitutional rights are being violated.
Okay. Not a problem with that. Okay, but you're talking about them bringing a charge, a constitutional charge against you. Okay.
Even the charge that they brought is not even mandated in the Constitution.
You're right. It's not. It's not mandated in the Constitution. It's mandated in the laws of the state of Florida.
And the laws of the state of Florida are to be consistent with the actual Constitution. They're subordinate to the Constitution. If I'm exercising a self-provision of the
Which Constitution are we talking about? United States Constitution or the Florida Constitution?
we're talking about the United States Constitution, and we're talking about the original 1838 Constitution.
Okay, well, that Constitution has been amended several times since then.
According to the state's website, the clerks of this office in this state are still authorized under that, and because the clerks, I'm just going by what it says on the actual website, but it affirms that the clerks are still under that 1838 Constitution.
Okay, but the clerks didn't charge you,
But
sir.
the clerks are the ones who are signing off on the oath of offices for the individuals who are acting in public office.
Okay, not a problem. I respectfully disagree, but okay. In terms of the charge, okay, the charge is a proper charge. I'm trying to find out what's the statute number, counsel?
For the no valid driver's license charge, I believe it's 322.031.
322031.
That's what I think it is. Double check.
Hang on, we'll find out.
Also,
Yes, sir.
I think there's a provision in that charge that states that all I would have to do is actually prove that I have a license or something from another jurisdiction.
Mr. Bay, listen to me. See, you missed the whole point. based on what you just said.
Okay.
I just told you, you don't have to prove anything. Okay? You don't have to prove anything. Absolutely. You have the absolute right to remain silent, the absolute right to hold the state to their burden. Now, like I said, if you choose to, okay, and you know, that's the difference. If part of your defense would be potentially, hey, I had a valid license from the state of New Mexico, okay, on my person on that particular date, and I tried to show it to the officer or whatever, and they refused to take a look at it, but it was valid and I had it on my, that's a potential defense for you or any other state, okay? But again, you have now morphed over into the factual determination of what did or did not happen, or whether you did or did not have a valid license from any jurisdiction, this jurisdiction or any other jurisdiction, okay? Even if you had an international license, okay, from the sovereign kingdom of Sierra Leone, okay, or any other place, okay? But what I was alluding to back, I was looking at the statute, Florida Statute 322.031, says drivers must be licensed. Except as otherwise authorized, a person may not drive any motor vehicle upon a highway in the state unless such person has a valid driver's license issued under this chapter. Now, that seems to limit it to this chapter, meaning Florida, because this is Florida law. But hey, if you got a valid license from California, Hawaii, New Mexico, wherever, then potentially that's a defense that you could raise. But making these arguments on that point goes to a factual basis, not as a basis to whether or not the state has provided a valid charge based upon the laws of the state of Florida under the Florida statutes. And that's why I say the difference in terms of whether or not this is a constitutional issue. They did not charge you, if you will, with a violation of the Florida Constitution, of a specific constitutional provision. They charge you with the violation of the Florida state laws based upon the state's authority to make law within its own context. Okay. So, yes, sir.
Okay, so the United States of America doesn't issue driver's licenses, so I'm not under.
Not the last time I checked, and maybe they do or they don't, but I'm really not sure.
As far as I know, they don't require U.S. citizens. The United States of America doesn't require U.S. citizens to actually have driver's licenses. So
The United States of America?
yeah, there's
State
no,
Florida does.
yeah, but the United
The
States
individual
of America,
states.
But the United States of America, the laws of the United States of America supersede those laws of the state of Florida. Plus, the rights of the people also supersede the rights of the state because
Really?
Yes, because the state is a function of the people. Public officers are public service. They hold offices because they chose to accept that they would perform certain duties which are the respecting and protecting of the
Absolutely,
people's
absolutely.
rights.
And those same people that you're talking about then send their elected representatives to the respective states' legislature in order to make laws, in order to govern those people within that jurisdiction, okay, who represent those individuals. And this particular law, I would dare say, came out of that. And it is the current state of the law in Florida at this time, okay?
Okay, but according to the rules, it states.
Which rules?
They-
Don't just say rules, there's a whole lot of
Oh,
rules
I'm
out there.
sorry. Well, it says a self-executing constitutional provision may not be restricted by the legislature. The legislature never addressed traveling. I was traveling.
Okay,
The legislature only addressed driving.
okay.
So I come out of the jurisdiction of the actual legislature once I actually accept that I'm traveling.
I like that. I like that. Traveling as opposed to driving, right?
Yes, sir.
Okay. So what's the appreciable and substantive difference?
Actually, just like they call bus drivers, they say a driver is someone who's actually licensed. I'm sorry, who's actually in the business of moving goods from one place to another.
That's one definition of it. Yes, I would agree with that.
Okay, and then the other aspect of it is the fact that a driver, again, it goes back to a legal definition, referring to someone performing a duty on behalf of another, usually a state, in order to secure some sort of wage. So I'm looking at, well, a traveler is somebody who just simply travels.
Absolutely.
And the free inhabitants have...
Travel how, sir?
But though, by any means I so choose.
Okay. Motor vehicle, potentially?
A vessel, not a motor vehicle, because again,
Really?
yes, because a motor vehicle actually puts the actual property up under the jurisdiction of the state by actually calling it a motor vehicle. But for all purposes and for all intended purposes, it is actually property.
Really? Train?
A train, that's a motor car. That's the same thing. It's a train or a motor car.
Travel, right?
Yeah, for travel.
Absolutely. Ship?
Uh-huh.
A ship?
Yeah.
A vessel?
Mm-hmm.
Right. Traveling. To go to and from one place to another by car, train, plane, ship, to take a trip, to move from one point of another. It's literal in plain meaning definition. To travel is egress and ingress and transportation. So synonymously, traveling and driving, okay, because the driving is the operation of a motor vehicle by an individual, okay, a person, all right, moving from one place to another. And by instances in traveling, in driving rather, because as you operate the motor vehicle by driving it, okay, because it is under your control by going forward, reversing, turning, steering, braking, doing that. In essence, what you do when you drive is you travel. Okay, so it's synonymous with one another. Let's don't split hairs and say, well, I wasn't driving, I was traveling. I respectfully disagree with you. So let's cut to the chase here. Based upon what I have in terms of the argument, sir, I do not find that there is sufficient legal basis to dismiss this matter. I find that the statute, Florida Statute 322.031, is legally sufficient that the state can bring this charge, and there's no legal basis to dismiss the charge on a legal ground. So I'll deny your motion to dismiss. Now, if you like the case set for hearing, trial, get the officer here, and everybody can get a chance to say their piece. You can challenge the officer, ask any questions that you want or not. So, totally up to you.
Well, at what point will I be able to get proof that this court has jurisdiction to act?
You just got it.
Actually, no, I did not.
Yes, you did. Unless you show me that I do not have jurisdiction to ask, which you have not done.
Well, I asked for proof because I have a right to be shown proof that this court has jurisdiction.
I do, sir. Listen to me, listen to me, listen to me. This is your motion, okay? And as I keep telling you, you have the burden. And if your argument is that I do not have jurisdiction, then it's your argument to tell me why I do not have jurisdiction, and not my impetus then to tell you that I do have jurisdiction, okay? Because I'm vested with the jurisdiction of this court as being a duly elected constitutional officer of this state, okay? So if you say I don't have jurisdiction, then tell me, give me some evidence to tell me why I don't have jurisdiction.
And I'm using it based on the fact that the state has remained silent on the issue when I question the state, because the state bears the burden of proof if I ask such a question.
I respectfully disagree, sir. There has been no proof that this court does not have jurisdiction. When I asked that question, you have provided me no information, no proof, no laws, okay, to otherwise indicate that this court does not have jurisdiction to hear a matter that was charged under the laws of the state of Florida within Hillsborough County, okay?
What about under the laws of the United States?
I deny your motion, sir. The motion is denied. Now, so if you want to appeal my ruling, go right ahead, appeal the ruling, or if you want to have a final hearing on this matter to resolve it, then we can do that too. So, choice is yours.
I'd like to see proof of jurisdiction.
I'm not going to keep beating dead horse, sir. I made my ruling. You can respectfully disagree with me. So be it. I have no problem with that.
But you affirmed in the last case that I did actually have a right to challenge the jurisdiction, and I do actually have a right to receive proof that the court has jurisdiction to act in this matter.
What part of I just explained to you 5 minutes ago did you not get, sir? I don't have to prove anything to you, sir. It is once again, I'm saying this for the last time, okay? Your motion, you had a burden to come forward to say that the court doesn't have jurisdiction. You have not done that. I repeatedly asked you to show me proof of that, and you have not done that. What you've done, sir, is tried to switch the situation and ask the court for me to validate something and prove something to you. Not my motion, sir, and I'm not doing it. Okay, now, I made my ruling. I gave the reasons for my ruling. If you disagree with my ruling, that is your right to disagree. Okay, and you can take whatever legal action that you deem necessary. So be it. So here's what I'm doing, okay? Let's set this case for trial, please. All right. Trial will be had October 23rd, 9 a.m. That's trial date. This courtroom. 10:23, 12, 9 a.m. Sir, at that time you have an opportunity to speak about what the factual matters, what did or did not happen. If you have witnesses that you'd like me to hear from on that day, please make sure that they are here. And state have your witnesses and be ready. Mr. Clerk,
Yes, sir.
do we have anything else?
No, sir.
Mr. State Attorneys, anything else? All right, Mr. Stanley.